Welcome back to the 2014-2015 Medical Dental Legal Update, a 20-hour program on medical malpractice, risk management, healthcare law, practice management, and selected clinical topics. The following presentation, Practice and Personal Asset Protection, features David B. Mandell, JD, MBA. Mr. Mandell of Fort Lauderdale, Florida, is an attorney and a principal of the financial consulting firm OJM Group. He specializes in risk management, asset protection, and financial planning, and has authored a number of books for doctors, including For Doctors Only, A Guide to Working Less and Building More, Wealth Protection, MD, and The Doctor's Wealth Protection Guide, endorsed by 5 state medical societies. Mr. Mandell is a frequent national speaker, and his articles have appeared in over 100 publications, including over 30 medical specialty journals. You may contact Mr. Mandell with your questions and comments at 877-656-4362 or by email at mandell@ojmgroup.com.
Hi, I'm David Mandell from the OJM Group. At OJM, we've helped over 1,000 physicians in 48 states with a whole host of planning areas, including corporate structure and benefit planning and tax reduction at the practice, personally in terms of asset protection and tax reduction and financial planning, investing. And today we're going to talk about a topic that I think is extremely important, which is asset protection, both at the practice and the personal level. Now, as somebody who practiced law exclusively for 12 years as a lawyer in California and New York, and every day helping physicians with asset protection planning, it's probably not surprising that our first couple slides here are disclaimers. And really the point of these are that the education I'm going to start with today, and that I'm going to give you on asset protection planning, is certainly very important, and you're going to learn a lot. But these are general principles, and just like a patient coming to you, and you giving a lecture on a particular medical condition, how that applies to a particular patient, just like with me, how it applies to a particular client, you really need to get that advice one-on-one from someone licensed and experienced to provide that. So I want you to sit back, take notes, learn and listen today, get some major principles. You'll probably hear some things you haven't heard before. And then think about how you can take that advice and actually work with an advisor to put that in place for you in your home state. Now, first I will commend you because you're here at the AEI seminar, you're learning, and you should be congratulated for that. And I've been part of the AEI course for 4 years now. And one of the reasons I'm excited about doing it today, just as I have for the last 3 years, is this is an educational process. Today you're going to learn, but it's just the tip of the iceberg. And both AEI and myself are committed to keeping that education going for you. So at the end, you're going to hear about some opportunities for more free education, but I wanted to tell you about this opportunity right now, which is since 1998, I've been writing books for physicians. And this book that you see here, For Doctors Only, is our national book. We have some books in particular states and for particular specialties as well. But as a gift from AEI, we want you to have a copy of this. So make sure you note this and follow up with us, and I'll give you that follow-up information at the end of the talk. But for any AEI participant, attendee, you can get it for free. And whether it's a hard copy book, the old school kind, or you want it in a Kindle or iPad version, we can get that to you. And it's all for free, and it's taking these concepts that I'm going to speak about today, and some I don't even get to, and give you the opportunity to learn more. So I encourage you to take advantage of that. Now, not only do we have 1,000 physician clients at OJM Group, but personally, I come from a family of physicians. In fact, there's been a Mandell practicing medicine in the United States for almost 100 years. My brother is a cardiologist. My father's a radiologist who's still practicing in his 70s, and my grandfather before him. And I've seen asset protection planning impact my own family and the 1,000 physician clients I've worked with over the years. And the reason is stress. You go into medicine, like my family has, generally to do well and to do good, to help patients. And when you're doing that, but yet you know every patient, every procedure, every diagnosis you make could turn into a lawsuit in the future adds to a level of stress that few other have in their professions. And it's not surprising the data we're looking at right here. This major study that came out that I'm referring to in this slide here, 87% of physicians say that they're moderately or severely stressed out on a daily basis. And over half, 63%, say that they're more stressed out than they were in the past. Now, there are a lot of reasons for that. I mean, certainly the changes in healthcare regulations are a big part of it. Certainly the reimbursements and the problems of reimbursements actually going down in many specialties and for many procedures is part of it. But I certainly am here to attest, both from a family of physicians and from a consultant to 1,000 more, that the lingering and sort of ever-present concern about being sued and about that kind of liability is a big part of it. And so I think today, learning about the different techniques you can apply at both the practice and personally to protect what you've built, to protect those assets and income streams so that if you are ever sued, you're not vulnerable, you're not exposed, that you have a solid level of protection, I submit will make you a better physician in that you will reduce your stress. It's certainly not going to relieve the potential of liability, but you won't go to bed at night thinking that you're completely exposed. And so there's 12,000 payouts from the latest data we have from 2012. That means there's probably a big multiple of that many lawsuits that actually get filed, right? Because very few actually turn into payouts, but some do, and you don't want to be the one that has a significant payout, and those payouts can be significant. We have over $3 billion of payouts just in 2012 alone. So I think asset protection is important for a lot of reasons. It can help you reduce taxes. It can help you be have a better financial control of your finances. It can lead to better financial planning, estate planning. But I think the number one reason is so that you reduce your stress as a physician and give better patient care. And so keep that in mind as we go through the asset protection planning today. So in today's presentation, we're going to cover a number of different areas. First, we're going to talk about common liability traps. Where do these potential claims and lawsuits come from? Second, we're going to talk about practice planning, corporate planning, and how to shield some of the key assets and what an ideal corporate structure looks like for a private medical practice. Then we're going to talk about probably the most important asset that you're concerned about and that our clients are concerned about, which is cash flow. And what can we do there? And the nice thing about protecting cash flow is it also has the side benefit of reducing taxes in many circumstances. And again, the odds of losing assets to a lawsuit are low. The odds of paying taxes, as we all know, is 100%. So if we can do something that can protect cash flow and save you taxes, well, why not do that? And then finally, we'll focus on personal planning, which is protecting personal assets like your retirement savings, like the home, like other investments against claims. So let's start with the common liability traps. Now, in a couple of slides ago, we talked about the statistics on medical malpractice. 12,000 plus payouts, 3 billion plus in awards just in 2012 alone. And certainly that's probably on the mind of most of our clients, most of our physicians, and probably you sitting watching this lecture. However, I would submit to you that while malpractice is certainly crucially important to protect against, the second potential area of liability, employer liability, is actually something I'm seeing more and more with physicians. I can tell you case study after case study after case study of physicians who've come to us and terminated an employee who was really a problem, but they didn't document their file, and they ended up having to pay a wrongful termination claim. Folks who were in a group practice, and whether they were involved or not, one of the physicians in the group ended up doing some things that were judged, or at least had to be settled as sexual harassment. And so they ended up having to pay out for that. And again, those types of risks generally, when a client lease comes to us before we've done a good analysis for them, they don't have insurance for that. So while malpractice is probably top of mind, most physicians have malpractice insurance. Certainly where I live in South Florida, there are some who go bare. But very few physicians or employees in general have employer liability insurance, and sometimes you can get that. sometimes it won't be covered, and that's why asset protection planning is important. Another area of liability that I've seen creep up over the last decade is liability for billing. And that can be, something from Medicare in terms of overbilling and getting an audit, or from private payers. It could be penalties for violation of anti-kickback rules or Stark rules, et cetera. As I said, the regulatory environment for physicians is more difficult than it's ever been. And if you fly foul of that, sometimes you can have liability there as well. Another area even related to that is HIPAA. Another area of regulation, and certainly if there's violation of those regulations, you can have liability for that. And then for physicians who own real estate, just the plain old garden variety slip and fall, and personal liability for things like car accidents, et cetera. The nice thing about asset protection planning is if we put it in place properly, it doesn't really matter what the source of the liability is. It will be effective. So you, by doing this type of planning, it doesn't really matter which types of liability are out there, but my point here is really there's more than malpractice. There are other things to be concerned about, and even if you say, hey, listen, I've got a great malpractice policy under, employed by a large institution, personal asset protection planning is still important for employed physicians because you are still driving, because you may still have real estate as rental real estate, because you may have teenagers driving. And so that liability can come back to you. So asset protection is important. It's important for malpractice, but it's important for a lot of other reasons as well. So now let's talk about the fundamentals, the basic building blocks, the things you have to understand, sort of asset protection 101. And this slide, I've tried to encapsulate in this diagram that. I could probably spend an hour just describing this diagram, and certainly in the book, which I hope you all will get, there's a little more description in depth here. But the basics here, the things you really want to take away, are the two extremes in the middle. Okay? Now, as an advisor to physicians now for 20 years, someone who practiced law for 12 years, and then as a consultant now for 8 years, I wrote the first book on asset protection planning for physicians. Literally, I think it was in 1997, the Doctor's Asset Protection Guide, which became the Doctor's Wealth Protection Guide and a whole host of other books. But for about 12, 13 years now, I've been using this sliding scale. And the reason I think it's important is, one, physicians have to understand that you look at each asset by asset. So you can't say to me, am I protected or not? That's not the right question, because I have to look at, well, what's the asset? Is the real estate and the practice what we're concerned about? Is it your personal investment portfolio? Is it your home? Because you may have great asset protection for one asset and none for the other. Okay? Each individual asset is looked at. We can't really say from a global point of view, we have to look at it asset by asset. The second thing is the whole idea of protected or not protected, the black and white nature of that is not accurate either, because there are different levels of exposure and different levels of protection. So in this diagram, I've tried to impart that knowledge, in that at the top end of the scale, +5, is what I think all attorneys in this field, consultants, folks like me who practice in this day in, day out, would say is protected, quote unquote, +5. These are assets, and we'll talk about them more later in the hour, that are protected by either state or federal law, meaning they're exempt. And that term means something, exempt. It means it's exempt under federal law from a bankruptcy point of view, meaning you could even file for Chapter 7 bankruptcy and it's exempt, it's outside of that, so you get to keep that asset on the way out of bankruptcy. Or it's state exempt, which means under state law, either you elect under state law in a bankruptcy action or outside of bankruptcy, just a normal lawsuit, the state law shields that asset in a certain amount. So certainly we are really, when we're working with physicians, trying to get them to leverage their exempt assets as much as they can, because one of the good things about using exempt assets is they're automatically protected. So you don't need to pay lawyers. You don't need to pay state fees. You don't have to make your life more complex. Those asset classes are better protected, and we'll talk about those. So that's something I think everybody would agree on. The other extreme is another area where I think all attorneys would agree on, which is -5. These are assets that have no protection whatsoever. You own it in your name. There's no exemption for it. You get sued, you could lose it. Okay? Now, everything in between There's a little bit of probably debate among, 5 lawyers. You might get 5 different opinions. But the idea is the tools in between, tools like limited liability companies and limited partnerships, which we'll talk about, trusts, different types of joint ownership, like we'll talk about, tenancy by the entirety and joint ownership. These are asset classes, or these are ownership forms that are not clearly off the table like exempt, but they're also not totally exposed like -5. They make the creditor go through hoops. They make it expensive. They make it difficult. They put you in a position to negotiate a settlement. They put you in a position of strength in that worst case scenario when you have liability. So what we're trying to do for most of our clients, it's not realistic to get to a client to +5 across the board in every asset. It's just not going to happen. What we're going to see today, and what our goal for clients is to move them from any significant negative positions to more positive positions. And if we can do that without high expense, and if we can do that even sometimes by saving you taxes, so you're actually getting paid to do it by the government, then why not do it? And I think that's really the perspective. Reduce stress, feel better about treating patients because you're not worried about being sued, and get as many of your assets in the positive position as possible. Now, another concept that's really important, we have a whole chapter in the book on it, is the idea of the best asset protection is not asset protection. Now, what does that mean? It seems like a very Zen thing to say. Well, what it means is, if we go back to the scale, we think about the +5 assets that are totally exempt, that are off the table, that are protected under federal and state law. When I start to tell you these tools, you may not think of them as asset protection tools. Your home, primary residence, your 401k or qualified retirement plan, an IRA, a cash value life insurance policy, an annuity. All of those asset classes in different states are +5, are totally protected, and some under federal law. But you might not think of that as asset protection planning. Hey, I have a home because I want a nice place to live. I have a 401k because I want to put money away for my retirement. I have insurance because I like the investments, the tax-free growth, and I like the fact that I'm going to have some death benefit for my family. And all of those things are true. So are those asset protection tools, or are they not? And that's really the point, is that the best asset protection tools actually have a lot of other benefits to them. And so there's a real important principle here, which is that the better asset protection planning, the tools have other benefits as well, whether they be tax reduction, estate planning, long-term tax growth, financial planning, financial management, better asset allocation. If you're doing something purely for asset protection planning with no other benefits to it, it's not as powerful as if you have a tool that has asset protection benefits but many other benefits as well. So keep that in mind. Now let's start with the practice. So for those of you in private practice, this is really important because you're earning all of your income, or I imagine most of your income, from the practice. It's very valuable in terms of its assets to your long-term wealth. And it's probably the most vulnerable to lawsuits, because if any claim is coming out of the practice, whether it be for employee claims or malpractice, harassment, and wrongful termination, any of that stuff, if it's related to the practice is also going to be sued and could have liability. So one of the first concepts we try to get clients to think about if they have a private practice is not just using one entity for that practice. There's no rule, there's no law in any state that says you have to run a medical practice as one entity, okay? And just like that old adage we learned when we were in 2nd grade, don't put all your eggs in one basket, it really is that simple for corporate planning. Don't put all your eggs, including your cash flow, including your key assets in the practice, in one place. Now, I use my example. Whenever I'm talking to clients, I'll tell clients about what I do, because I think it's important. Just like if I was going to a physician, if you had this condition, what would you do for yourself? So we have now 3 owners at my practice, yet we have 6 different entities. Okay? Now, for tax planning, and which isn't the subject of today's talk, there's some significant reasons why we do that. We have entities taxed as S corporations, entities taxed as C corporations, entities taxed as partnerships. But from an asset protection point of view, this is also important as well, because I don't take all of my income from one entity. We don't have all of our key corporate assets in one entity. So if there were a claim because of a wrongful termination of an employee, or there were a claim by a client because of something we did there, or there were a business claim against the main entity, they might have a claim against that entity, but they wouldn't have it against the related other 5 entities. Okay? And a medical practice can do the same thing. So oftentimes, you today, what are you doing You're sitting in a conference learning about practice and management-related issues. You're not seeing patients, yet you're playing an important role for the practice. For those of you who have private practice, you're acting as the CEO, you're acting as the president of that practice. Well, you're acting as in management capacity. Well, if you're doing that, and I guarantee you're doing that every week, the studies show 15 to 20 hours of a physician are spent on non-medical elements, whether it's paperwork or employee issues or payer issues, et cetera. You could spin off a separate entity for those services and then provide those services back to the practice and take some of your cash flow there. Well, why would you want to do that? Well, one, now you're protecting some of that cash flow from a claim against the main practice because it's coming to you from the management services entity, which is justified by what you're doing from a management point of view. Now, you should have a real management agreement, just like we have in our situation. But that is one place you could start. For some of you who maybe are in an aesthetic practice, you could use a marketing entity. Some of you might want to put your billing coding people in a separate entity and have those services there. So there's a lot of ways when you start to creatively think about it that you can separate the main practice, the medical provision, from management. And I think that's something that you might want to consider. Now, I would say one place that most physicians have gotten this advice of multiple entities is with real estate, and for good reason. It's a good standard operating practice to separate the real estate. So I can't see a show of hands, but if I asked you how many of you have real estate in your practice, my guess is that those who have real estate in the practice have been given the advice to not own the real estate in the professional entity itself, whether it be a PC or PA or whatever the medical practice entity is, but to have it in a limited liability company, what we call an LLC, and then lease it back to the practicing entity. And this is good advice. Now, when you did that, and for those of you who are familiar with that, most people don't think of it as asset protection. They said, oh yeah, our accountant or our lawyer said we should own it as a separate entity and then lease it back. And in fact, what it is asset protection planning right there. And it's the application of this concept of multiple entities. Don't put all your eggs in one basket. So you can see this with, I see it every day with practices all over the country, over and over and over and over and over and over on the real estate side. In fact, just this last weekend, I had a call with clients in Alabama who had their long-term practice structure, their building, owned in an LLC and separated. And I'm reviewing it to see if it has the right language and formalities in it. But they at least took the right first step in separating and having it a lease between the practice. There are some things they could improve, but they did sort of the basics. Now, that is applied to real estate quite often in medical practices, but I don't see that same concept applied to other types of assets. It could be, I would say probably the next most important asset is probably the equipment or other hard assets in the practice. Again, there's no reason that the equipment and hard assets, especially in some practices you have very expensive medical equipment, that you have to keep that in the practice as a potential source of funds or assets for a claimant. You can separate it outside just like you did with the real estate or just like you could, and then lease it back to the practice. Same exact concept as the real estate, just apply it to the equipment. We have some clients who have developed important intellectual property. Some orthopedic surgeons who have some devices they patented, et cetera, and they're getting paid royalties. And again, we generally recommend that that intellectual property be separated into a separate limited liability company typically, and that way those income streams and that valuable asset is not subject to claims of practice or even claims against them personally. We don't want them owning it personally. We'd rather have them in a separate LLC. So the application of the concept, don't put all your eggs in one basket, isn't so simple, and it's not the same for everybody listening to this lecture. But the concept itself is probably something that all of you should think about who have a private practice or have personal assets like that, and think about and get the advice on how that concept applies to you. The most important asset, I would say, in a medical practice, as in any small business, is cash flow. There's that saying, cash is king, and I could not agree with that more. And so how does one typically protect cash flow in a practice? Well, the best ways to protect cash flow are the tools and the word we like to use in our firm a lot is buckets. The buckets that the cash can go in before it hits your name that can A, often reduce taxes significantly, B, can have tax-favored growth along the future, C, can certainly be a major part of your wealth and retirement plan, D, in circumstances when you have employed physicians, can act as golden handcuffs to keep employed doctors there, and probably most important for what we're talking about today, E, are asset protected at the very highest levels. So what are these types of tools? Well, number one, they're qualified retirement plans. Qualified plans make up a group of plans that you probably know as 401ks, defined benefit plans, defined contribution plans, profit sharing plans. All of these are qualified retirement plans. Related to those, but not qualified retirement plans, are IRAs. Now, SEP IRA works very similar in that you get a deduction like you do with a qualified plan. It grows tax-free like a qualified plan. You pull it out at ordinary income rates. And there are some pros and cons to qualified plans from a tax point of view. Roth IRAs are different. You pay all your tax today. The money goes into a Roth. It grows tax-free. You pull it out tax-free. There are some pros and cons to that. We're not talking about taxes today. From an asset protection point of view, IRAs are protected under federal law very similarly to qualified plans, as we'll talk about. Under state law, there's generally the same level of protection, but some states, some key states like California, largest state in the country in terms of population, does not protect IRAs the same way they do qualified plans. So again, physician listening to this who's a resident of California, if they have an IRA, we're going to look at it very differently than, say, a client from my home state in Florida, where IRAs are protected at the highest level in an unlimited way. So again, gets back to my earlier comments that some of this depends on state law. Now, this is also, these tools, a great example of a thing I was talking about before, which is the best asset protection is not asset protection. Most of you probably use these types of buckets, qualified plans, fringe benefit plans, if you use those. We'll talk a little bit about that. IRAs, because of the tax benefit up front, because of the long-term tax growth. You may not be putting money in your 401k thinking, asset protection planning. But in fact it is, and it's not by happenstance that these tools that have very significant other benefits, tax planning, retirement planning, are also at the top of the scale at +5. So let's talk about qualified retirement plans. In my estimation, again, working with 1,000 physicians and talking to thousands more, about 90 to 95% of medical practices and physicians who are employed take advantage of a qualified plan. Now, if you're employed at a hospital, it might be a 403B, it might be a 401k. If you're in a private practice, it could be a 401k or a profit sharing plan or a defined benefit pension plan, et cetera. But they're all qualified retirement plans. Now, today we're talking about asset protection. The asset protection is terrific. How does that work? Well, first, under federal law, and again, that comes from the bankruptcy world. It doesn't mean you have to file for bankruptcy because we know that you always could, and so that protections are there. Some clients, some physicians may end up filing for bankruptcy, but that's where we get the rules from. And under federal bankruptcy rules, qualified plans are protected at an unlimited value. Now, there's some caveats if you've committed securities fraud or you've put money into the qualified plan after you had the liability, because there's always the timing issue. Everything we're talking about today, the planning needs to be in place before you have a problem. Once you have a problem and you put the planning in, it can be undone. That's a fraudulent transfer rule. And again, there's a chapter on the book on that. So timing is always crucial. But beyond those sort of caveats, qualified retirement plans have the highest +5 protection. However, okay, you got to look at the tool in its entirety, just like a medicine you're giving to a patient. Certainly the asset protection, great, but if you own your own practice, you have to look at the employee costs. Plus, you have to look at the long-term tax treatment. The taxes are terrific today, and this is why most people use a qualified plan. We have one in our own practice. But also, you have to recognize that they're going to be taxed at ordinary income on the way out. So again, the chance of being sued is low. The stress can be high, but the chance of being sued successfully and losing assets is low. The chance of paying taxes is 100%. So we have to balance qualified retirement plans and their beneficial asset protection with their long-term tax treatment. I don't like a lot of my clients having a lot of their significant wealth subject to future income taxes, because income taxes, if we look at this slide, even though we're at highest marginal rates have gone up since the fiscal cliff in the beginning of 2013. So now we have the highest marginal rate at 39.6 when it was 35. So even though those rates have gone up, when you see this slide, and you can congratulate the U.S. income tax on its 100th year birthday, because it started in 1914. Even though that rate has gone up, we're still relatively low. If you look at this chart that's on this slide, or you look it up, or you go into our book and you see every year, you'll see that for most of the 20th century, tax rates are higher than they are today. And a lot of our successful physicians are not going to be in a very low bracket when they retire, because they're not going to retire until they have the income that they want to sustain their retirement. So they're going to be maybe not at the top rate, but certainly in the top 2 or 3 marginal brackets. So when you take that into consideration, you don't want to protect assets from lawsuits only to lose them to future taxes. So what does this mean? This doesn't mean that qualified plans aren't a good idea. They are. They're terrific asset protection, but you have to go into it and analyze it from a financial point of view. That is really my point. We have a qualified plan. I put some money into it, but I put a lot more money into a fringe benefit plan than I do in my qualified plan. I have a large balance in my qualified plan, and I love the fact that it's well asset protected. So if you're going to have a qualified retirement plan, and you're going to use that as a major part of your asset protection planning, make it as efficient as possible. Make sure that you're taking advantage of your employed, of the options that are put in front of you as efficiently as it can be for you. If you're an employer, if you own your private practice, even more importantly, to look at the formulas to make sure you're getting as much bang for your buck as you can vis-a-vis your employees. I talked to a physician group this week who, very successful, does not have a qualified plan. They haven't had one for 2 or 3 years because the employee costs were too high relative to what the doc could put away. We're going to show them some new formulas that might actually end up working out well for them. But you have to look at this, and if you haven't looked at it for the last couple of years, some of the rules has changed, you should. Now, I mentioned IRAs are related to qualified plans, but they're not. There's federal bankruptcy protection at the highest level, okay, under bankruptcy, but under state laws, I mentioned, it varies. Most states do protect the IRAs at a high level. Some states, like California, which is the most populous state, do not. And so again, this is where getting a specific analysis of your situation is so crucial. Now, for some clients who have an IRA that's sitting out there from before, or they have their own practice, we might recommend they roll their IRA into a qualified retirement plan purely for the asset protection benefit, even if their contribution numbers are going to be the same. Even if there's no tax benefit to doing it, we're going to recommend that from an asset protection point of view. And that might be true for some of you watching this. Now, beyond qualified plans and IRAs, we find that very few physicians use any other benefit plans. They don't use non-qualified plans. They don't use fringe benefit plans. And this is actually a significant failing, I think, of most physicians, especially in private practice. Because when you look at 95% plus have qualified plans, and I would, in my estimation, not scientific, I would say less than 5% have non-qualified or fringe benefit plans, which have their role as well for many clients. In fact, there's one fringe benefit plan that you can do in addition to qualified plans that allow a private practice to put in, actually, we have some clients putting over $100,000 a year into this type of plan, but for many clients at least up to $100,000. And the financials can be much, much better than just purely paying your tax and investing it. And sometimes it actually compares better for the client than their qualified retirement plan. And it works differently. With this fringe benefit plan, it works more like a Roth IRA, but better than a Roth. A Roth IRA, as I said before, you put the money in 100% after tax, so you paid all your tax on it. You put it in a Roth, it grows tax-free, it comes out tax-free. So you're getting the tax-deferred growth and tax deferral and tax-free access, which is powerful. And it can be a good hedge against your qualified plan, where you get a deduction today, but you're subject to those future income taxes we're worried about. This fringe benefit plan, you actually get a partial deduction going in, so better than the Roth, but has the tax-free growth and the tax-free access. So it's sort of like a Roth on steroids, is one way to think about it. Does it make sense for everybody? No. Is it something that could make sense for your practice? It could, and it certainly is a great hedge against your qualified plan, which is taxed differently. I call this plan a hybrid because it has elements of a qualified plan and elements of a non-qualified plan. It's under the tax code, a fringe benefit plan, and it's been in the tax code for 40 years, and it's in the 2014, just like the 2013, just like the 2012, IRS's own brochure on fringe benefit plans. So it's not something I'm making up, it's right there and it's been there for a long time. But yet very few medical practices take advantage of it because, as you can see from this slide, in the bold and the caps, that it's only available for C corporations. So most medical practices are taxed as an S corporation, about 70%. So that means there's probably another 10% that are disregarded entities and sole proprietorships and other types of entities. So there's probably only about 15 to 20% of medical practices today that could even take advantage of this plan for their physician owners. So this gets back to what we were talking about before in terms of corporate structure. I was saying it's so important to have a multiple entity corporate structure from an asset protection point of view because you want to put cash flow and other assets in multiple baskets. Don't put all your eggs in one basket, and that's true. But this concept here can relate to that in that by having multiple entities, you could have entities taxed as S corporations, which most of you probably are, and C corporations and partnerships, et cetera, and then take advantage of planning like this. And by the way, this fringe benefit plan, this hybrid plan, is at the +5 highest level of protection in most of the states, or I'd say about 20 states. And in the other 30 states, it can be structured within a limited liability company or a trust for a very high level, +2, +3 level of protection. So not only is this a tax benefit that you could take advantage of, it's also another bucket to protect that cash flow that we talked about. But you can only take advantage of it if you have the right corporate structure. So this is how these things relate. Going back to the corporate structure concept, if you have multiple entities and you have them taxed differently, you may not only be better protected in that structure, but it also may allow you to take advantage of different tools underneath the structure that you couldn't have before because you were only in one entity. And this is, again, what I do in my practice. We have multiple entities. We have entities that are taxed as partnerships, S corporations, and C corporations. And each one of those things allows us to not only protect assets better, but to do some things tax-wise that we weren't able to do if we just had one entity. Another concept in the multi-entity or corporate structure approach that can also protect cash flow extremely well is the small captive insurance company. Now, I've been working with small captive insurance companies, again, since the late 90s, and they've become, when I first started doing it, or working with people who did this, physicians never heard of this concept. Now, over the last really 12, 13 years, more and more physician groups have used captives on the malpractice side and for other risks, and they're starting to realize the benefits of small captive insurance companies. One of the things that's so interesting about captives is total flexibility in how you can use them. Some can use them purely for malpractice and to reduce the practice's exposure or take some of the profits back from the insurer, and that's certainly part of it. Other clients can use a captive for everything but malpractice. So some of those risks we were talking about at the outset, employee claims, defense against healthcare fraud audits, defense against payer audits, defense against sexual harassment or wrongful termination, and all of that. Risks that you probably have today, but you don't have insurance for. That captive could provide that insurance, and because of the way the captive's structured, any cash flow that flows into that captive, one, can be structured for a very high level of asset protection, and two, will give you tremendous tax benefits. Because just like when your practice buys insurance from an outside insurance company, whether it be Geico or MetLife or anybody else, when it buys, let's say, your malpractice insurance, it's going to get a deduction for that. It's a business expense. Well, the same thing would be true here. When that practice buys insurance from its captive, it's going to deduct that. That's fine, and that's pretty simple. What's interesting about small captives, if they're structured properly under a particular code section, is that that captive will not pay tax on that income. It's one of the few places in the tax code where you can have a for-profit company that you can own that will not pay tax. So unlike when you separate real estate and you get a deduction for rent on one side and then you pay tax on the other side, here you might get a deduction on one side and pay no tax on the other side. So it's certainly a very tax-favored structure, but what we're here talking about today is asset protection. And a captive properly structured can really give you two levels of asset protection. One, provide you defense-type policies that you don't have today, meaning there's a host of risks that every practice has that does not have insurance for, and we talked about a couple of them already, but there's probably a lot more. Two, that the funds that go into the captive themselves, if they're not used to pay claims to cover you for costs that you wouldn't have insurance for, if they're sitting there, eventually they can come out to you in retirement, but in the meantime, inside of the captive, they can be structured for some of the highest level of protection. Not +5, but certainly +2, +3, +4. Inside of, that stock can be owned inside of trusts, inside of LLCs. So the captive can really be a tremendous protector in two ways. One, tax planning. Two, risk management and giving you insurance coverage you didn't have before. And I'd say three, the actual protection of the dollars sitting in the captive. So captives can be a tremendous tool on a number of levels for asset protection and tax planning. But one thing to really keep in mind is that creating a captive insurance company is creating a real insurance company. And it's a significant in terms of costs, it's significant in terms of time commitment, and it needs to be put in place with in the right circumstances. Typically, it's not going to be applicable for a small, closely held practice, but for larger practices. Now, this doesn't mean larger in terms of number of docs. I've seen it work successfully even in 1 or 2 physician practices, but it's got to be large enough in terms of the revenues, large enough in terms of the risk profile that it's worth the cost and complexity to put it in place. And again, we have a chapter on this in our book, and I encourage you to read more about it and see if it might be applicable for you to consider. Now let's talk about personal planning. And this is probably what most people think of when they think of asset protection planning, is how do I protect my personal assets? And this is something obviously that's relevant for whether you're practicing private practice or you're employed, okay? We're talking about your personal assets, and let's talk about the different ways those could be exposed and protected. Well, the first thing is, how do you own it? How do you take title, as lawyers would say, in that type of ownership? Now, a very common misconception is the idea of spousal ownership, which is in a situation where you have a married couple, where one spouse has a lot of liability, let's just call them the physician, and one spouse does not. Let's say they stay at home or they're a teacher, they don't have a lot of risk profile. And the idea is, hey, I just put all the ownership in the spouse's name, the less liable spouse. Well, I don't like that for a number of reasons. One is it's not always effective. In fact, in many cases, in many states, it's not going to be effective at all. Because if you can imagine, especially if the non-liable spouse in most cases is not one earning a lot of income, and the physician spouse, who is more liable, is earning the income, it's not hard to trace the fact that that home, or yet you put in the spouse's name, or that portfolio that you put in the spouse's name, or that other asset that you put in the spouse's name really came from income that you earned. And so at least in most cases, there's something called substance over form, which is a concept in the law. And the substance is, it's really your joint asset. The form is you put it in their name. Now, I say that, again, with the large caveat. One of the books we wrote for physicians, and I mentioned we wrote it in 4 states. Well, one state we wrote a book specifically in a state for docs in that state is in Ohio. And again, if you're in Ohio and you're in Georgia, if you're in New York and you're in California, we wrote books specifically for you. If you're an orthopedic surgeon, we have a book specifically for orthopedic surgeons. We'll soon have a book out specifically for dermatologists. So not only can you get the national book, we'll be happy to give you something more specific if we have it. But the point on the Ohio book is we wrote that book with 5 attorneys and 5 law firms throughout the state of Ohio. Now, there's not a lot of things you get 5 lawyers to agree on, okay? But one thing they all agreed on was under Ohio law that a physician, let's say with a spouse who did not have much liability, could put that home in the spouse's name and effectively protect it against claims against them. And if they filed for divorce, it would still be treated as a joint asset, okay? And I made sure all of them agreed to that before it went in that book. That's not the general rule, okay? That's not the rule in the states that I've been practicing law in. Certainly in California, which is a community property state, it's community property, so it's liable to both spouses completely, the opposite end, which we'll talk about in a second. So again, caveat, general rules. To understand what's specific in your state, you got to get specific advice. So I generally don't like spousal ownership because it either won't protect, or in some states, if you get divorced, you will lose it if you gave it out all the way to the spouse in terms of title. So generally not recommended. There's tenancy in common, TIC, joint ownership, JO. These basically are treated like they sound as joint. So if you own that, if you own ownership in that ownership form, whether with a spouse or another joint person, like a family member, brother, sister, father, mother, then if there's liability against you, probably half of the equity of that asset could be taken. If there's liability from their side, half of the asset equity could be taken. So again, I don't like those in terms of protection. We consider them -3 in terms of the sliding scale. Tenancy by the entirety. Now this is an ownership form available in about a dozen states. We have this in Florida. Tenancy by the entirety is an ownership form only available to married couples. And what this ownership form states, or what the laws in those states respect, is that a lawsuit against either one of the spouses is ineffective. So it's really kind of +5, totally protected against a claim against either spouse. So if there's a claim against the physician and the non-physician spouse isn't available, or isn't vulnerable for that, then that tenancy by the entirety protection is total. However, tenancy by the entirety also is totally vulnerable to claims against both spouses. So a car accident that might have them both liable, or something that their children did, maybe a car accident of their kids, or if the physicians are working together in the practice, either as physicians or maybe as a practice manager, then you could have no protection. So tenancy by the entirety is important, and for some assets and in some states we recommend it, but it's not the cure-all. And in over about 3/4 of the states it doesn't even exist. Community property is in about a dozen states too, mostly the western states, and this is the worst possible ownership form, because if it's community property, if an asset is community property, it's available 100% to debts against both spouses. So it could be a claim against the physician. If it's community property, it's all vulnerable to that claim. It could be a claim against the non-physician spouse. There's liability. They can come after any of the community property. So in community property states like California, where I used to practice, in many of the western states, asset protection planning is crucial, because you can't just rely on community property states, community property law. Otherwise, everything will be -5, because that's really the way it is in community property states. So when we're looking at personal protection, we always want to start with exempt assets. Well, why? Number one, they're protected better than any other asset. They're +5. They're exempt, just like the word sounds, under state law. We talked about the federal protections under qualified plans and IRAs. But you want to take what the state gives you. I mean, I can't tell you how many physicians, and probably many of you sitting in the audience, are sitting in states that have tremendous exemptions in different asset classes, and yet you're not taking advantage of them in your overall financial plan. Asset protection through exempt assets is not only the best protection, but you don't have to do any gifting, which you have to do if you're doing trusts or LLCs or limited partnerships. You don't have compliance costs, which you have for trusts and limited partnerships and LLCs in terms of annual fees. You don't have to pay accountants to do extra tax returns, which you do if you use LLCs or limited partnerships or trusts. And you don't have to pay people like me, lawyers and others, to set these things up. And you might even have to pay additional taxes. All of those things are the case if you're going to use limited partnerships and LLCs and other tools, which we'll talk about in a second. Now, I have LLCs and limited partnerships and tools, so they make sense and they're part of every plan. But I'm also maximizing my exempt assets, and many physicians are not. So until you maximize your exempt assets and you can take advantage of things that are just clearly protected without you having to pay anybody to put them in place, then we start to use the limited partnerships and LLCs. But one of the key takeaways from today is learn about what the exempt assets are in your state. And again, certainly happy to talk to you about that on a free consult and let you know what they are in your state. Certainly we've got a lot of data on that in the book. And then make sure you're maximizing that as it makes sense in your financial plan before you start spending a lot of money with lawyers. I can't tell you how many docs have come to me and said, I spent $10,000, $20,000, $30,000 on this offshore or elaborate asset protection plan when they still yet hadn't even used their exemptions in their state, which are going to protect better than any legal tool can, because by definition they're exempt. So make sure you understand your exempt assets and take advantage of them in your state. Regardless of how good your exemptions are, you're going to need LLCs, limited partnerships, and FLP means family limited partnership, as part of your planning. Okay, I have them, and I'm in the best state in the country for exempt assets, which is Florida. So exempt assets are powerful, but they're limited. So you're going to need tools like this for your portfolio or second home or rental properties, et cetera. And the way LLCs and limited partnerships protect assets are twofold. One, like we've talked about with the corporate planning, by having assets in different entities, you've separated them and made it so you're putting your eggs in different baskets. That's inside protection. So if you have two pieces of rental property and you put each in a separate LLC, then no matter what happens at that real estate, environmental claims, slip and fall, fire, et cetera, by keeping it in a separate LLC, not only have you protected your own assets, but you've protected it against the other piece of real estate. So that's inside protection. Outside protection is, let's say you get sued personally for malpractice, and now someone wants to come after that piece of real estate and the equity. That's why you don't have it in your name, because if you had it in your name and you used to own the property in your name and someone got a judgment against you, they can take it. It's -5, there's no protection. By having an LLC in place and having it done properly, you can take advantage of the charging order protections, okay? Now, what is a charging order? We look at the next slide with the diagram. Basically, what I'm trying to get across in that diagram is if someone gets a charging order against you, which means they have judgment against you, and they want to come after the LLC or limited partnership interests. If the LLC or limited partnership is done properly, they can't just come into that LLC and get voting rights and vote you out. They can't force you to make a distribution. They can't get to that real estate itself. They can't get to the rents. They can't get to any cash flow. They can't force you to sell the real estate. That LLC is creating a great moat around that piece of property. But they get something, and that something is called the charging order. And again, we have a whole chapter in the book on this. But essentially what the charging order allows them to get is distributions. So if a distribution is made from that limited partnership or LLC, that money, you decide, because you're the manager or the general partner, if you decide you're going to make a distribution of that to yourself, out of the entity, to yourself, they can step into your shoes and take it. So that gives them some rights. But what's the chance of you making such a distribution if someone's sitting there where they know they have a charging order? 0. And by the way, they can't force you to make a distribution. So LLCs and limited partnerships put you in a position to negotiate a settlement. They're certainly not as good as +5, because in +5, the exempt assets, they can't get a charging order. They have no right to distributions. They have no right to anything. It's exempt. It's off the table. But with an LLC or limited partnership, you can't take it off the table, but what you can say, what you can do is put yourself in a position to say, in the worst case, someone has a judgment against me. They want to come after that entity. They're not just going to take it like a -5 asset. They're not going to be able to get any distributions. I'm going to be able to keep them at bay. Now, like anything, the key is in the details and making sure the LLCs have the right language, making sure that the operating agreements are right. I've looked at the work of 200 different law firms since I've come out of the practice, and I can tell you that most LLCs and limited partnerships are not maximized for asset protection planning, and they could be improved. So you want to make sure that you do the right structure and you do it properly. The last couple things we'll talk about are protecting the home and other real estate. Now, again, the best way to have the home protected is to take advantage of the homestead protection. Now, again, these vary completely from unlimited homestead in Florida to 0 homestead in New Jersey, with everything in between. So for some clients, all they need to do is be in that state and take advantage of homestead. Hopefully you're one of those lucky ones. For those who aren't as lucky, maybe in some states, like I talked about Ohio, spousal ownership can work. In some states, tenancy by the entirety, which we talked about, are effective. In some states, a trust might be the best tool. In other states, maybe an LLC. In other states and other circumstances, maybe it just means not building up a lot of equity in that home, what we call a debt shield, which is instead of putting an extra $10,000, $20,000, $30,000 into the home, you put it in another asset because the home is not well protected in your state. Again, it depends on your particular asset mix and the rules that we're following for you. Debt shield, very simple concept. It basically means don't put more money by paying down the equity than you need to. And again, with low interest rate environment, sometimes that makes sense financially as well. That same concept as for the home can be applied to the non-home. Now, with a non-primary residence, which could be rental property, which could be your second home, oftentimes limited liability companies, LLCs, make sense because for a primary residence, there's some tax benefits that basically make it not as ideal to put a primary home in an LLC. But those rules, those primary residence rules, do not apply to a secondary residence. So in most cases, we're recommending either rental properties or second homes, if they can be, to be owned in limited liability companies to take advantage of those charging order rules that I talked about. So today, in a very short amount of time, I've tried to get you up to speed on a number of different concepts with asset protection. The idea of not putting all your eggs in one basket in terms of the practice. The idea of protecting cash flow through qualified plans and fringe benefit plans and other tools like captives. From a personal point of view, the importance of how you own assets in terms of titling, the importance of exempt assets, using limited partnerships and LLCs for different assets that go beyond that, how potentially to protect the home and other non-home real estate. At OJM Group, we help clients with this in all 50 states. We have clients in 48 states. But as you can see, these elements bleed into other elements: tax planning, corporate structure, benefit planning, et cetera. And at OJM Group, that's what we focus on. In fact, one thing we focus on specifically when we're looking at a practice is tax reduction and asset protection, tying those things together. And one thing we offer that a lot of clients haven't heard before is our firm commitment, which says if we're looking at your practice, if we can't show you ways to double our fee in terms of tax savings, we'll refund the fee. And that's a pretty powerful thing to stand behind, and we do that, and we've done that for hundreds and hundreds of physicians. We encourage you to take advantage of it. So as I mentioned at the beginning, education is the most important thing. That's why you're here today. That's what you've learned about. We encourage you all of you should get a copy of the free book, whether you want the hard copy book, Kindle, or iPad. We'll get that out to you as an AEI participant. We have free newsletters. We have free special reports. I'm happy to do a free consult with anybody to talk about what we do and how we might be able to help you and see if there's a fit. I thank you for listening. I encourage you to keep the education going. Look at the emails and on my slide here and contact us, and we'll be happy to get you the free materials as an AEI participant. Thank you again.
That concludes another in the continuing series of programs on medical malpractice, risk management, healthcare law, practice management, and selected clinical topics. Presenting was attorney David B. Mandell.